today. And the chair now recognizes the gentleman from Wisconsin, Mr. Senator Sensenbrenner, for 5 minutes.
Thank you very much, Mr. Chairman. To begin, Director Mueller, let me commend you for your 12 years of very dedicated service in an agency that obviously had to change its targeting and its mission as a result of 9/11. And you and I got our jobs as leaders, me as chairman, about the same time. You're about ready to retire. I was retired as chairman in 2007, but I'm not about ready to retire from Congress or asking questions. So I'll begin. Let me start out with two quotes from then Senator Barack Obama. First is, President Bush has put forward a false choice between the liberties we cherish and the security we provide. I will provide our intelligence and law enforcement agencies with the tools they need to track and take out the terrorists without undermining our Constitution and our freedom. The second quote, which comes from the same speech in Washington of August 1st, 2007, the Bush administration acts like violating civil liberties is the way to enhance our security. It is not. There are no shortcuts to protecting America, unquote. Now, Director Mueller, you have served both under President Bush and through the transition to President Obama. What new privacy protections did the FBI implement under President Obama, and were those in place when the FBI applied for the FISA application that was leaked to The Guardian?
Well, we have internally a privacy officer. The Department of Justice has a privacy officer. I do not know specifically, but in programs such as this or other areas where we initiate collection of information, it goes through our privacy shops.
That's not my question, with all due respect. Were there new privacy protections that were implemented by the new President, Barack Obama, after January 20th, 2009, when he took office?
Are you asking, were there?
Yes.
I'm not certain of the timing of whatever additional privacy protections were instituted, if there were.
Okay, so there might not have been. Well, I'm very interested in your comment about the Al-Mittar case, which was somebody who got on the radar screen before 9/11 and before the Patriot Act. Section 215 of the Patriot Act, which I had a hand in drafting, requires that the business records FISA warrants or orders be directed solely at foreigners who are the targets of an authorized terrorism investigation, and not on United States citizens unless they're contacted or involved with foreigners. Now, I don't think that Section 215 would have put a crimp on identifying Al-Mittar if that was in place before September 11th. But my question is, with respect to the FISA order that was leaked to The Guardian, is with the narrowness that Section 215 is, and as I have described it, how can Section 215 be utilized to scoop up the phone records of American citizens who are not in communication with a foreigner who is an object of an authorized terrorism investigation?
To a certain extent, I have to defer to the Justice Department on the legal theory and the FISA court. I can tell you generally that there is the belief that the body of telephone toll data has in that information that is relevant, may be relevant in the future, has been relevant in the past, and that its collection in this matter thereby satisfies the requirement for relevance according to the court.
Well, the question of relevance is the same type of question that could be issued either with a grand jury subpoena or with a national security letter without involving the Patriot Act. Here you involve the Patriot Act in something that is done in secret, and there are no due process protections in place because the recipient of the FISA warrant can't tell what records he's turned over, and that's not the case with either national security letters or grand jury subpoenas. Now, I guess what my concern is that there really isn't any way for anybody whose records are turned over to approach the FISA court or any other court because they don't know about it to try to get the order quashed. And an FBI agent was the one that signed the affidavit to get that order. And my time is up.
Let me, if I may just follow up with one observation, and that is, as we all know, these particular records are not covered by the Fourth Amendment. The Supreme Court has held that to be the case. And secondly, the determination as to the legality and that standard has been addressed by the FISA court in the affirmative to support this particular program.
The chair recognizes the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you. Let me just suggest, by the way, that that 1979 decision of the Supreme Court that a phone bill is not protected by the Fourth Amendment might not apply to a lot of this stuff today, given how pervasive and privacy invading this metadata has become compared to what could be done in 1979. So I don't know that I'd totally rely on that precedent to do everything that's being done. But let me ask you the following. Under Section 215, and I would also like to associate myself with the remarks that a dragnet subpoena for every telephone record, et cetera, every email record, although I know they don't do that anymore, but they could again tomorrow, and they did do it, certainly makes a mockery of the relevance standard in Section 215. If everything in the world is relevant, then there's no meaning to that word. Now, some of us offered amendments to narrow that several years ago, and in retrospect, maybe we should have adopted those amendments. But that's no excuse for a misinterpretation of relevance to the point that there is no such meaning to the word. Now, secondly, under Section 215, if you've gotten information from metadata, and you, as a result of that, think that, gee, this phone number, 873 whatever, looks suspicious, and we ought to actually get the contents of that phone. Do you need a new specific warrant?
You need at least a national security letter. All you have is a telephone number. You do not have subscriber information, so you need the subscriber information. You would have to get probably a national security letter to get that subscriber information. And then if you wanted to do more,
if you wanted to listen to the phone,
then you have to get a particularized order from the FISA court directed at that particular phone of that particular individual.
Now, is the answer you just gave me classified?
Is what?
The answer you just gave me classified in any way?
I don't think so.
Okay, then I can say the following. We heard precisely the opposite at the briefing the other day. We heard precisely that you could get the specific information from that telephone simply based on an analyst deciding that, and you didn't need a new warrant. In other words, that what you just said is incorrect. So there's a conflict.
I'm not certain it's the same answer to the same question, but I'm sorry, I didn't mean to.
Well, I asked the question both times, and I think it's the same question. So maybe you'd better go back and check, because someone was incorrect.
I will do that. That is my understanding of the process.
Okay, I don't question your understanding. It was always my understanding. Yeah. And I was rather startled the other day, and I wanted to take this opportunity to...
I'm happy to clarify it.
Thank you. Second, we have heard from Director DNI Clapper of the terrible, horrible damage to national security done by, what's his name, Snowden, by releasing this information. I'd like you to comment on that. I don't understand how national security was breached. We knew publicly, from 2006 at least, from a report in the USA Today on May 11, 2006, about the basically the existence of a massive NSA database of metadata from domestic phone calls. That was reported back then. We debated it in this committee and on the floor of the House in connection with reauthorization, I believe in 2012 and in 2008, but at least several times. So that was known publicly. The only thing that was not known, as far as I can tell, that was revealed was the specifics of that court order, which tell us nothing other than what was already public, plus you can have it for whatever length of time it was. And even the stuff about Section 702, we debated that at length in the FISA Amendments Act debate a couple years ago. So that was pretty known. The only thing that may not have been known is the exact technical capabilities. But my assumption, and tell me why you think this is not correct, is that any terrorist with half a brain in his head would assume that all electronic communications are vulnerable and may be subject to interception. And how does what's his name just released add to that assumption or change that assumption?
Well, and let me address the last point first, because I often hear it that any terrorist who has a brain would figure it out. The fact of the matter is they're terrorists and they're terrorists. And I can speak generally, but I cannot go into some of the more details as to specific harm to national security. But I can tell you every time that we have a leak like this, and if you follow it up and you look at the intelligence afterwards, there are persons who are out there who follow this very, 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 very closely, and they are looking for ways around it. One of the great vulnerabilities that terrorists understand is their communications. And they are consistently looking for ways to have secure communications. And any tidbit of information comes out in terms of our capabilities and our programs and the like, they are immediately finding ways around it. And if we lose, as one of my problems is that we're going to lose because we've got chat, VoIP, a number of other things, lose our ability to get their communications, we are going to be exceptionally vulnerable. I ask you to get the classified briefing as to more specifics, but let nobody be misled in this. This hurts national security. Now, the issue is, how do you balance that against privacy? Understand that. And you may come down differently than others, than the FISA court, than me perhaps. But all I can say is that there is a cost to be paid.
Time of the gentleman has expired. The chair recognizes the gentleman from North Carolina.